Deputy Registrar, can you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Barbados, judgment delivery in CCJ application BBACR number 1 of 2023 between Alex Tasker and the United States of America. The members of the delivery panel are Mr. Justice Saunders, President, and the presiding judge.
Good afternoon, everyone.
Mr. Justice Anderson.
Good afternoon, Counsel.
Madam Justice Rajnath.
Good afternoon, everyone.
Mr. Justice Barrow. And Mr. Justice Burgess.
Good afternoon, Counsel.
May we have the appearances, please? Thank you.
Good afternoon, Your Honors. If it may please you, I appear along with Mr. Andrew Pilgrim, and we lead Mr. Clay Hackett on behalf of the applicant.
Yes, good afternoon again.
Good afternoon, Your Honors. Mr. Alliston Seal, Senior State Counsel, Senior Counsel for the respondent in this matter, and I appear with him, Oliver Thomas.
Yes, good afternoon, and I apologize for Justice Barrow, who is having some problems with his camera, but he's online now.
I'm happy to see all of them, President.
Yes. I propose to read a summary of our judgment. Of course, this is merely a summary and is not to be regarded as the official judgment in the matter. After a hearing, the applicant, Mr. Alex Tasker, was committed by a magistrate to surrender to authorities of the United States of America to face charges of money laundering and conspiracy to launder money. Immediately after the committal, Mr. Tasker's attorney indicated orally his client's intention to appeal the magistrate's order. In accordance with his duty under Section 19 of the Extradition Act, the magistrate informed counsel of the need to seek leave to appeal from the Court of Appeal, or alternatively, seek a writ of habeas corpus within 15 days of committal, as required by Section 20 of the Extradition Act. Instead of heeding the magistrate's advice, Mr. Tasker's attorney purported to appeal the committal order by issuing a notice of appeal to the Court of Appeal in keeping with Section 240 of the Magistrates' Courts Act. This was the wrong procedure, and by the time Mr. Tasker's attorneys recognized their error, the 15-day time limit for seeking leave to appeal to the Court of Appeal had expired. Notwithstanding, a few days after the expiry of the time limit, the attorneys filed an application with the Court of Appeal for leave to appeal to the Court of Appeal in the proper form. The Court of Appeal dismissed this application on the ground that it was filed late. The court held that it had no power to embark on a consideration as to whether time should be extended, or alternatively, whether the purported appeal filed under Section 240, but within time, should carry any weight. Mr. Tasker then sought special leave to this court to appeal the decision of the Court of Appeal. Upon consideration of the notice of application and the affidavit in support filed by Mr. Tasker in accordance with Rule 10.14 of the CCJ Appellate Jurisdiction Rules 2021, and also upon consideration of the affidavit in opposition filed by the respondent, a 3-judge panel of this court, comprising myself and 2 other judges, refused the application for special leave. The panel concluded that on the papers presented, there was no arguable case advanced by Mr. Tasker justifying the grant of special leave. Dissatisfied with the manner in which his special leave application was addressed, Mr. Tasker applied to the court to review its decision, effectively applying to reopen the proceedings. The court ordered the parties to file written submissions on 1, whether the application to reopen the application for special leave should be granted. 2, if it were granted, whether the decision to refuse special leave should be reversed. And 3, if Mr. Tasker succeeded on 1 and 2, whether the appeal of the Court of Appeal's decision should be allowed. The matter was argued before a 5-judge panel in Barbados. With respect to whether the application to reopen the proceedings should be granted, the court had in the past interpreted Rule 10.14 as meaning that it was open to it to dismiss an application for special leave at any one of 3 stages, one of which was after the notice of application for special leave and the affidavit in opposition of the respondent are filed. The court, however, agreed with Mr. Tasker's attorney that given the manner in which Rule 10.14 is drafted, a litigant is justified in being aggrieved if an application for special leave is dismissed on a consideration only of the notice of application for special leave and the affidavit in opposition of the respondent. Upon a re-examination of Rule 10.14, the court accepted that litigants are justifiably entitled to believe that although they must state in their application for special leave all such facts in support of their application, the law grounding the application which they propose to argue will be elaborated upon either in another written document or orally before the court, or both in writing and orally. The court agreed that its decision denying special leave should be quashed, and that in the interests of justice, the application for special leave should be reopened. As to the application for special leave, and if successful, the appeal itself, the court agreed with Mr. Tasker's attorney that the Court of Appeal was in error in taking the view that it had no power to decide for itself whether to hear the application for leave to appeal. It was open to the Court of Appeal in all the circumstances to determine whether this was a case in which it should give effect to the right to a fair trial and facilitate access to justice. The authorities cited by counsel demonstrated that strict compliance with time limits is subject to the right to a fair trial. In other words, the Court of Appeal does possess an exceptional jurisdiction to extend the statutory time limits in those circumstances where strict compliance would operate to deprive a litigant of his right to a fair trial or limit his right to access the appeal process. Thus, the court was of the view that the Court of Appeal was in error in considering that it had no power or jurisdiction or discretion to exercise in all the circumstances. This court did not accede to the view that it should itself exercise the discretion vested in the Court of Appeal, either to treat the notice of appeal filed on 8 September 2021 as an application for leave brought within the statutory 15-day time limit in accordance with the Extradition Act, or alternatively, to extend the time for filing of the application for leave to appeal to the Court of Appeal. Instead, the case was remitted to the Court of Appeal to exercise its own discretion on these matters and to determine afresh how best to treat with Mr. Tasker's clearly expressed desire to challenge the magistrate's order of committal. The court therefore ordered that the order of this court refusing special leave dated 31st July 2023 is quashed. Special leave is granted to the applicant to appeal the order of the Court of Appeal dated 27th April 2023. The appeal is allowed. The matter is remitted to the Court of Appeal of Barbados, and the order for committal made by presiding magistrate, His Worship Mr. Ian Weeks, on 8 September 2021, and the order restraining the state of Barbados, inclusive of the Barbados Police Service, and or its servants and or agents of the state of Barbados from embarking on any course of conduct which would result in the surrender of the applicant to the respondent's authorities, is further stayed pending the hearing and determination by the Court of Appeal of Barbados of the matter or until further order. Now, when we sent out the advance copy of this judgment, there were some remarks made as to imposing a time limit on the Barbados Court of Appeal within which it should hear the matter which has been remitted. We have decided not to make that a part of our order, but of course, we would expect that the Barbados Court of Appeal will take up the matter as soon as possible. We in this court, as you would have seen, when this matter was first sent to us, I think it was in April, endeavored to give a decision as quickly as possible. The first time around might have been a little too quickly, but matters of this nature ought to be addressed as soon as practicable, and we fully expect the Barbados Court of Appeal to honor that notion. That, therefore, brings us to the end of these proceedings, unless there's anything from council. If there is not, then I would ask Madam Deputy Registrar to close the proceedings. Thank you, everyone.
Deeply obliged to your honors.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnetly. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Burgess. Thank you, Council. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.
Good day.